Law in stateless society is something brought up a lot. It's really not a very complicated issue. Rules and the enforcement of rules both predate and still operate independent of state law. Today there are many private arbitration services. That is, when people make contracts, often they will write in the contract a clause saying something like, should there be a dispute with this arrangement, both parties will submit to the arbitration of X private arbitration agency. This prevents the individuals from having to deal with the irredeemably corrupt and prohibitively expensive arbitration of the state, question-beggingly called the justice system. So how would anarchic courts work? Well, let's say two people have a dispute. They can't resolve it, and so they submit their dispute to an arbiter that they both agreed upon, probably a dispute resolution agency with a reputation for impartiality. It could even be a religious agency. Now, there's not necessarily any force behind the ruling, but there could be. But for now, let's assume it's just a commercial dispute and there is no force behind the ruling. The court rules that person A owes person B 2 ounces of silver for violating a contract. In this situation, person A has two choices. He can either abide by the ruling and pay the 2 ounces, or he can ignore the ruling. If he ignores the ruling, he will pay a price in terms of reputation, in terms of credit score, crime report, and/or personal reputation generally. Before one so casually laughs this out of hand, keep in mind that eBay sellers are kept honest with seller ratings, and according to the Internet Fraud Compliance Center, less than 1% of all auctions on eBay result in fraud, and that's with internet sales. Also, the reason people pay off small debts is not to prevent from going to court and facing the guns of the state, but to prevent a drop in their credit score. For most disputes, a stateless society would not be creating a completely new type of institution. Private arbitration with negative enforcement already exists and already works. The removal of state law would result in an expansion of what already exists, although the transition will probably be very difficult. What's more is that private law firms tend to be interested in restitution and demand a less exorbitant cut than a state monopoly, which makes sense given the nature of monopolistic institutions, which state law is. Also, 14% of the free market is underground, which is called the gray market and the black market. The gray market is the selling of legal goods without reporting the sales and thus not paying the taxes on them or having them regulated, and the black market is the sale of goods deemed illegal. As of this writing, the state comprises 30% of all economic activity in the area called the United States of America, which means about 10% of all economic activity in the United States is under the table, that is, in the black or gray market. When you go into either the black or gray market, you have given up access to police and the law courts, and access to private credit reports and private arbitration. This is because if you started to have publicly available credit reports for the underground economy, the cops would be all over that activity instantly. By entering the underground economy, one has also chosen to take on the risk of being caught by agents of the state and being thrown into prison. Despite this risk and hobbling of the underground economy, 10% of Americans choose to go underground. That is how worthless state law is. And it makes sense given how dysfunctional the United States legal system is. I'm not about to flesh out why. There are plenty of people who can give line and verse on just how crappy the legal system is, and it has just become common knowledge. Nobody defends the state courts today as being efficient. They just say that without the state courts, things would be even worse. And those who propose a free market solution are often chided for not being able to explain with apodictic certainty what will emerge from the impossibly complex web of interactions that is the free market. But of course, this is an argument against central planning and against the state's monopoly provision of justice. When mail delivery was a state monopoly and funded through taxation, many figured that without such an arrangement there would be no mail delivery, or that private mail delivery firms would charge exorbitant rates, would cartelize, would prevent the poor from being able to send letters, would develop local monopolies, would raise rates on time-sensitive goods like life-saving piece of medical equipment, and so on. And of course, I cannot explain how private mail delivery works, and even less so would I have been able to explain how it would work had I lived in the days when mail was still a state monopoly, except for some basic principles of how it would work and a theoretical model of a mail delivery firm, which is kind of what I'm doing now with other state monopolies such as law. The violent imposition of private law is another issue, which is more theoretical in a modern society since state law has a true monopoly in this area. That is, rape, assault, and murder never fall under the purview of private arbitration. One can look to how things were done in stateless societies in the past, the Western U.S. territories, Ireland, and Iceland, though I am less sure about the legalistic peculiarities of the stateless colonies Pennsylvania and Rhode Island. Murder was typically dealt with in kind. Rape and assault were dealt with severe punishments that the criminal was forced to endure at the point of a gun. So in a sense you could say that the committing of violent crimes led to an ideological/marginal state in relation to that criminal. That is, the criminal wouldn't be free from violent imposition of the law court's ruling by moving to another area. That is, it is a global marginal state, which was supported by the relevant population, the ideological state. Though this is not really a state in the way most would conceptualize it, more like a criminal on the run from those who he had wronged. And it does not lead to a state. For violent crime, this is how my theoretical private justice firm would operate. For murder, the victim's closest acquaintance determined by the court will determine the fate of the murderer within some parameters. I'm thinking of a life of forced labor would be appropriate, as would the death penalty, though prolonged torture would not be a choice according to my ideal private court. This may include significant lifelong financial restitution to the victim's closest acquaintance or to a fund determined by the victim's will. For rape, the victim, or if the victim is not in a condition of mind appropriate to make a proper determination, then the victim's closest acquaintance, chosen by the court, will determine the fate of the rapist within some parameters, similar to murder except with narrower parameters. With assault, it will be similar to rape except with even narrower parameters than that. There are many who have gone into much greater detail on these matters, and I implore the reader to explore the suggested material attached in the description. It is all free stuff available with any internet connection. Rules and the enforcement of rules, typically with negative enforcement for commercial offensive and positive enforcement for violence offenses, predate the state, and in many cases are dealt with privately within states, and have existed in stateless societies surrounded by states. And given the speed with which information currently spreads, there is little reason to believe that law cannot be dealt with today by private firms. And these private firms can be pure private capitalist law or a communitarian law firm that is a result of the homeowners association forming into a voluntary township.